Hello and welcome to the EDRM Global Webinar channel. My name is Mary Mack. I'm the CEO and Chief Legal Technologist for EDRM. Today's webinar is an EDRM collaboration with our trusted partner, eDiscovery Today. It's called Important eDiscovery Case Law Decisions for April 2024. Our faculty experts are Doug Austin, Tom O'Connor, and the Honorable Judge Andrew Peck. We welcome your questions and feedback in the console. Questions will be answered both during and at the end of the webinar. This webinar will be available for replay at your convenience for the next quarter, as are all of our EDRM webinars. Kaylee Wallstad, EDRM's Chief Strategy Officer, is here. Could you please tell us what resources are available for listeners today, Kaylee?
Absolutely, and welcome everyone to one of our most beloved monthly webinar series. We look forward to it every month. We also are loving our On24 platform with so many more ways for you, our audience, to engage. If you check out your console to the right of the screen, you'll see a question mark icon. This is where you can type in your questions for today's faculty, and we highly encourage you to engage there. Slides will be made available after the webinar has concluded. You'll also see a paperclip icon. That's for related content. And if you click on it, you'll see today's resources carefully curated just for you. On24 engagement tools descriptions for you to download to help you better engage with the platform. There's a link to click and subscribe to eDiscovery Today's blog and never miss a thing. It's certainly my favorite way to start the day. And we send huge congratulations to Doug Austin on his 4th year blog anniversary.
Here. Thank you.
And there's a link to click to learn more about the Honorable Judge Peck and how to engage with him. There's also a link to order your copy of Tom O'Connor's spicy new book, eDiscovery for the Rest of Us, recently updated in a collaboration with EDRM's trusted partner, NextPoint. And be sure to save your seat for next month's Case Law Edition on May 30th. And then up next on EDRM's webinar channel tomorrow, April 24th, Reasonable Cyber Best Practices, Sword or Shield, with the great Ron Hedges discussing the New York Shield Act. Speaker bios can be clicked and popped up to learn more about today's fabulous faculty. And just like Zoom, you'll see a smiley face emoji, and if you click it, you'll see many more reactions that you can click during the webinar, and we highly encourage you to engage with them. We're having a lot of fun with them on this platform, and you can give it a try now. And if you click the Twitter bird, you can follow EDRM and eDiscovery Today on LinkedIn, and be sure at the end to click the pop-up. This will allow you to auto-register for EDRM's webinars and skip the whole registration process. Once there, be sure to scroll down to the bell to subscribe and stay up to date with the new content. And back to you, Mary.
Thanks, Kaylee. And for our listeners, Doug Austin, he is the founder and editor of EDRM Trusted Partner, eDiscovery Today, celebrating its blogversary. Doug is an established eDiscovery thought leader with over 30 years of experience providing eDiscovery best practices, legal technology consulting, technical project management services, and more to numerous commercial and governmental clients. Doug has published the daily blog since 2010 and has earned J.D. Super Awards 3 times. Tom O'Connor is the director of the Gulf Coast Legal Technology Center. He's a nationally known consultant, speaker, and writer in the area of computerized litigation support system. Tom's consulting experience is primarily in complex litigation matters, where he's worked with firms of all sizes, and most recently the plaintiffs in BP's litigation. He has also been appointed as a technical consultant by various federal and state courts on cases dealing with large amounts of electronic evidence. And as Kaylee said, his most recent edition of his popular book, eDiscovery for the Rest of Us, was launched at Legal Week with EDRM's trusted partner, NextPoint. And the Honorable Judge Andrew Peck is a Chambers-ranked senior counsel at DLA Piper, where he advises on copyright and trademark matters, and also serves as a resource for the firm and its clients on litigation strategy and discovery issues from a judge's perspective. Judge Peck retired as a United States Magistrate Judge in the Southern District of New York after 23 years, but he wrote a boatload of opinions. We've got boilerplate objections, 502D orders, technology-assisted review. We've got a whole lot of them. And we are very grateful to all three gentlemen for their service on the EDRM Global Advisory Council. And over to you, Doug. Happy birthday.
Thanks, Mary, and welcome everybody to our April 2024 case law webinar on the EDRM network. We do indeed have another 6 cases to discuss this month, 4 of which were suggested by our own Judge Andrew Peck, who's already suggested 3 for next month. So I don't know what I'm going to do with all my free time, but I'll figure out something. Those cases for this month address disputes, including a dispute over producing a 30b6 witness, clawback of a produced document, sanctions for deletion of text messages, relevance and privacy of an unpublished autobiography, sanctions for failing to preserve video of a slip and fall incident, and discovery about litigation holds and ESI sources preserved. As a reminder, we do welcome questions, and we'll try to get to as many as we can, and we'll send out a copy of the slides after the presentation, so look for that too. Of course, any ideas expressed by us here today are our own, not those of our organizations, clients, or partners. No matter how full the agenda is, it will never eclipse the disclaimer. And before we get started with these cases, here's a quick note about the webinar format and sources of cases. This is the latest in a series of monthly webinars about case law, and the cases we discuss each month will be those covered on eDiscovery today. We provide links to each of the stories about the cases, which in turn have a link to the actual case ruling, where you can check out the full ruling itself. These case law rulings are available courtesy of Kelly Twigger's eDiscovery Assistant site, which is a great resource not only for case law, but also for federal and state rules, checklists and forms, and a glossary of legal and eDiscovery terms. eDiscovery Assistant has over 35,900 lifetime federal and state case law rulings, and they add as many as several hundred cases a month. eDiscovery Assistant is the definitive source for eDiscovery case law out there. And by the way, as you've heard, last month we teased a cake with 4 candles. So as you already know, it was to celebrate the 4th anniversary of the launch of eDiscovery Today, which happened last Saturday. As you can see by the numbers here, we've been a little busy over the first 4 years, and none of these accomplishments would be possible without your support. So thanks to all of you for reading the blog. And also thanks to all my partners and sponsors for their commitment to education and their support enabling the blog to continue to exist. And a special thanks to Mary, Kaylee, and EDRM for its support in helping eDiscovery Today get started, along with Craig Ball, and its continued support, including hosting this monthly webinar every month. And thanks to Tom and Judge Peck, along with Mary and Kaylee, for continuing to support those. In a few months, we'll be celebrating 4 years of doing these webinars, so stay tuned for that.
Wow.
Now, time flies, doesn't it? So, with that said, let's get into the cases. This first case involved a plaintiff who was exonerated after serving 19 years for a robbery and murder he didn't commit, and it was suggested by Judge Peck. And I must have really liked this case because I did something I've never done before in over 13 and a half years of covering case law. I covered it twice. I covered it at the beginning of this month, and I covered it again last Friday because I forgot I covered it the first time. I read all the cases we cover before selecting them, so of course I remembered reading it. I just didn't remember covering it. So 2,224 lifetime posts, number 2,223 was an oops. Regardless, once the Superior Court found the plaintiff factually innocent, the plaintiff then filed this action under 42 U.S.C. Section 1983, alleging the defendants deprived him of his constitutional rights by withholding or ignoring exonerating evidence. In response to plaintiff's request for production of documents, defendants repeatedly stated that various documents never existed or were not maintained, and thus defendants could not produce those responsive documents. Plaintiff therefore served notices of Rule 30b6 depositions seeking to address deposition topics, including policies and procedures governing preservation or destruction of documents, searches they conducted to identify documents requested in the RFP, and actions taken to respond to the RFP. In response to these notices, defendants objected and refused to produce a witness to testify. California Magistrate Judge Deborah Barnes rejected several cases defendants cited to support their position in refusing to provide a witness. Regarding the first case you see there, Judge Barnes stated, defendants' reliance on Ford is confusing as Ford supports plaintiff's motion. The court in Ford went on to endorse exactly what plaintiff seeks here. Regarding the second case, Judge Barnes stated, it appears that in Brand, a Rule 30b-6 deposition was held, which proved significant. And regarding the defendant's citation in the third case, Judge Barnes stated, the court in Friedman acknowledged that discovery on discovery is sometimes warranted, and that where a party makes some showing that a producing party's production has been incomplete, a court may order discovery designed to test the sufficiency of that party's discovery efforts in order to capture additional relevant material. Here, defendant's production has been less than incomplete. It's been essentially non-existent. And plaintiff is seeking discovery that could ascertain whether defendant's production has in fact been incomplete. Judge Barnes also rejected the defendant's objections as to burden and also the defendant's request for a protective order, stating defendant's argument is a broad allegation of harm unsubstantiated by a specific example or articulated reasoning. So the plaintiff's motion to compel was granted, and the defendants were ordered to designate 30b-6 deposition witnesses within 14 days, with the depositions to be completed within 35 days. So, Tom, does it seem to you that the defendants have been stonewalling every attempt to obtain discovery in this case? And if so, do you think Judge Barnes should have addressed that in her ruling with some sort of sanction, or is that premature?
Well, I think saying that they lacked any articulated reasoning in their arguments was pretty darn close to a sanction. Yeah, I mean, stonewalling, I don't think even begins to cover what they said. I mean, when the judge goes so far as to say that their productions have been less than incomplete, they have been essentially non-existent. That one was like, that took my breath away. I think if anybody's a poster child for violating Judge Peck's primary rule, these guys have got to be at the top of the list. As far as timing of sanctions, though, I think the judge clearly wanted to talk about letting those depositions go forward. You know, you said in the last paragraph there, they were ordered to designate their witnesses within 14 days, and the depositions would be completed in 35 days. The stonewalling was going to cease. And the judge's reasoning was in citing some of the misapplied cases that they had cited. She said the courts in Ford and Brand are not alone in recognizing the value of Rule 30b-6 depositions in dealing with issues such as those presented here, end quote. So I think the judge really wanted to see discovery play out before there was any talk of sanctions. But I would say they're looming on the horizon if that 35-day limit isn't met.
Yeah, and I'll just add one other thing, which is it did not seem from reading the case that the plaintiff moved for sanctions. Judges have to really be upset to sua sponte start the sanctions process rolling, and indeed due process requires notice to a party before considering sanctions.
Right. Fair point. Absolutely. Makes sense. So, Judge Peck, did you ever hear any cases filed under 42 USC Section 1983 when you were a judge? And given that these are cases involving civil rights, did you or would you handle anything differently in a case like this regarding the parties and their handling of discovery?
Well, handled lots of Section 1983 cases. And while it is civil rights, it's often things like police use of excessive force, correction use of excessive force, correction facilities, failure to provide medical care. all of which are important, but unfortunately, many of the cases were brought by pro se plaintiffs. Puckett had an attorney here, but many plaintiffs do not. The other thing that made discovery challenging, aside from the plaintiff being pro se, is that often the remaining defendants who are subject to discovery are the individual police or correction officers or whatever. And the entity, the prison facility, the NYPD, or technically the city of New York, was not a party, which made it interesting. Can you sanction the individual police officer when they have no control over what information the NYPD has, and yet the city or the NYPD is not a party to the action, or certainly isn't by the time discovery is ongoing, usually having been dismissed on a motion. Made life challenging.
Yeah, I would say so. Very interesting aspect to that, for sure. So, Mary, the defendants referenced several cases which Judge Barnes found didn't support their position. So what advice do you have for our audience regarding finding cases that are most likely to actually support your arguments in court?
Well, the first thing to do, of course, with a pile of cases is to read them.
And don't rely on ChatGPT.
And that
Right,
is correct. That is correct. And then also look for the holding and not the dicta. And then, is it from the appropriate jurisdiction? Same or similar fact pattern? Does the legal principle apply to those facts? You have to go through some mental gymnastics. But the other thing you can do is do something that we used to do way back in the day called shepherdize. And that is to take a look at the case and see if any other cases have cited it. Did they cite it in to strengthen their case or in opposition? And there are tools now that will actually show that to you visually if something's been cited negatively. And you should read those carefully.
And just to emphasize what Mary said, read the entire case. Don't find that sexy little quote and cite the case for that, and then not know that whether dicta or holding, as Mary suggested, the case actually went against you. And that is something that we as judges see quite frequently.
Yeah, very interesting. Certainly an interesting case, and we will move on to the next case.
Almost worth having covered it twice.
Almost worth having covered it twice. So certainly you can, yeah, and my write-ups were remarkably similar too. Go figure. So our next case is a product liability case regarding a medical stapler, also suggested by Judge Peck. And here, the plaintiffs and defendants disagreed on the designation of a document produced during discovery and the defendant's attempt to claw back the document from production. The court issued an order scheduling a hearing regarding the discovery issue and directing the parties to file a joint letter brief detailing the discovery issue and including the document for in-camera review. Defendants argued that the document was confidential and subject to the protective order, not responsive to discovery because the court limited discovery to the EEA circular stapler at issue in this case, not relevant because it concerned different products in a different operations facility than those at issue in the case, and protected by work product privilege. Texas Magistrate Judge Kimberly Priest Johnston agreed with the defendants that the document was confidential and found it was subject to the protective order, but disagreed with them on pretty much everything else. Rejecting the defendant's argument regarding the document being non-responsive and not relevant, Judge Johnson stated, defendants have not referenced any authority, nor has the court found any authority to support their proposition that responsiveness and relevance are proper bases upon which an inadvertently disclosed document can be clawed back. Further, the parties have not provided the court with any agreement between the parties that expands the ability to claw back documents because of responsiveness or relevancy. Judge Johnson also rejected the defendant's argument to claw back the document on the basis of work product privilege, stating, The document is a report prepared by the FDA. There's no indication that the document was completed in anticipation of litigation. Rather, as discussed above, EIRs are completed by the FDA at the close of an investigation of a regulated facility. There's nothing in the document that indicates that it contains legal theories, mental impression, notes, etc. of defendant's counsel, nor have defendants made any argument to this effect. Judge Johnson also rejected defendants' objection to plaintiffs providing any documents marked confidential to their expert, Dr. Jason Moore, who was a competitor of the defendants, stating, defendants have failed to demonstrate with particular and specific facts how the disclosure of the documents will result in significant harm. Moreover, as plaintiffs argue, Dr. Moore has already accessed these documents in a different case and thus has already learned of their contents. Because Dr. Moore has already learned the contents of the confidential documents in this litigation, the competitive harm, if any, is already done. So, Judge Peck, last year we covered a case where the court allowed a party to perform redactions of non-responsive content on documents being produced. Had Judge Johnson agreed with the defendants that the document was non-responsive, which she didn't, should they have been allowed to claw back the document?
No. I could stop there and donate the rest of my time to other cases, but I will say a little more. I mean, the prior case we covered, Magistrate Judge Parker from the Southern District of New York allowed responsiveness redactions. Most decisions do not. And other than privilege, and that is the beauty of getting a Rule 502D non-waiver order, you're supposed to do the work beforehand, so to speak. You're supposed to do a careful review of documents for production. And, you know, once you have produced it, too late, it's gone. The other side has it. I suppose, and Judge Johnson here, you know, emphasized no case law authority being provided to her. I suppose one could have an agreement with opposing counsel that, you know, either side can claw back a produced non-responsive document on the ground that it shouldn't have been produced because it wasn't relevant. But in 40-something years of practice as a lawyer and as a judge, I never saw such an agreement, and highly dubious that people will enter into such an agreement. Do the work ahead of time.
Yeah, makes sense. Well, speaking of doing the work ahead of time, Mary, we've seen a lot of disputes over inadvertent disclosures within productions and attempts to claw back those documents. So what can parties do to minimize the risk of inadvertent disclosures in the first place?
Well, we got the big hint on the 502D order. So there's always that. And then doing the work, you know, your workflow, having a master list of attorneys and law firms, and then noting which attorneys have hybrid business roles, because those are the ones that you know, you'd want somebody with a higher level of knowledge and experience to review. You use that list to create your potentially privileged tranches, and then document and train how the privileged and non-responsive documents will be coded, especially if it's a compound document like an email family or a document or like a PowerPoint with an embedded spreadsheet or something like that. Have consistent coding with quality checks at the coding level. And then, of course, it's your last check that's going to be absolutely critical. Your pre-production checks for your privilege, and then also for personally identifiable information that should be redacted.
Yeah, absolutely. Yeah, those are a lot of great QC steps along the way. And then, of course, with the 502D protection as your fallback, certainly want to have that as well. So, Tom, one of the things I found interesting about this case was that the plaintiff used an expert, Dr. Moore, that the defendants contended was a direct competitor of theirs. Should a party like that be able to serve as an expert and obtain access to confidential information in the case? Isn't that a conflict of interest?
Well, I mean, it depends, and there's a way to deal with that. And I mean, the judge, I think, found here that, in fact, the judge's quote was, the defendants have failed to demonstrate with particular and specific facts how the disclosure of the documents would result in significant harm. So you can't just say, well, this person's an expert and they work for a competitor. You got to be very specific. But moreover, in this case, and the plaintiffs argue this, the expert had already seen the documents in a different case. And again, as the court said, the Dr. Moore had already accessed these documents and thus had already learned of their contents. Because Dr. Moore had already learned the contents of the confidential documents in this litigation, the competitive harm, if any, is already done. So it was a moot point.
Yeah, and rightfully so. Obviously, water under the bridge once he's seen those documents. But certainly interesting that's the plaintiff expert was a competitor. So certainly will be interesting to see how things unfold there. And we'll move on to our next case. And now it's time to play the Family Feud. This was a case dealing with a family trust that got so contentious, the parties had to agree to a non-disparagement clause. With respect to the motion for spoliation sanctions, the court made a finding that defendant Susan Holmes' duty to preserve arose at least as of May 9, 2022, when she entered into the settlement agreement, which contained the provisions regarding payments to be made, as well as the non-disparagement provision and accompanying remedies for its breach. The court deferred ruling on the spoliation motion to allow Susan Holmes an opportunity to determine if the messages that were lost could be restored or replaced through additional discovery, which they couldn't. The court also ordered Susan Holmes to file a notice indicating whether text messages and emails between her and her son, William Holmes, had been produced for the time period of August 2nd, 2022 to the present. Finding no evidence of spoliation with respect to William Holmes or Carrie Armstrong, who stated she only received one message from Armstrong or Holmes, Nevada Magistrate Judge Craig Denny denied the motion for sanctions for both of them. However, regarding messages between Susan Holmes and her daughter Jennifer Holmes, Judge Denny stated, Susan and Jennifer Holmes both state that the fact that they lived together reduced the need to send messages via text or presumably email, but neither states that they never texted one another. The record demonstrates Susan Holmes was fairly prolific in texting other persons, including her son and opposing counsel, and those messages contain many spiteful references to Armstrong. Therefore, the court finds it hard to believe that there were no messages between Susan and Jennifer about Armstrong. Continuing, Judge Denny stated, even more troubling is that it appears Susan Holmes continued to delete her text messages after she received the litigation preservation letter in this case. She states that she had a policy of deleting text messages after reading them, but she clearly should have ceased this policy after receiving the preservation letter. She also indicates she did not know that her iPhone had a setting that deleted messages after 30 days, but the preservation letter also should have put her and her counsel on notice to check her phone settings to make sure that relevant information was not being deleted. Even with that setting enabled, she admits that she still engaged in selective preservation of messages. She kept the messages that she thought were important to the case, but deleted the others. This is indicative of intent under Rule 37E2. However, regarding the plaintiff's request for default judgment against Susan Holmes, Judge Denny stated, while Susan Holmes' conduct in continuing to delete messages after being served with the litigation preservation letter is egregious, it has not so harmed Armstrong that he is unable to present his case. So he instead opted for an adverse inference instruction sanction against Susan Holmes for intentional deletion of text messages. So, Mary, what responsibility does defendant's counsel bear in Susan Holmes' failure to preserve text messages, if any?
Well, the defendant's counsel has a duty to oversee preservation. They've got a reasonable inquiry mandate about, so they should be talking to their clients about how to preserve, and in particular, I think counseling against selective deletion of messages, and to find out what their practices are, and then to caution against that, and then of course the making sure that the auto delete settings are also set correctly, and in very high profile cases, or I think it would be wise to actually take a snapshot and then let your client go on after basically backing up the phone so that nothing is lost.
Yeah, definitely would be a good way to avoid those scenarios. Matt Linehan chimes in with a comment that she didn't know her iPhone had a setting that deleted messages after 30 days. And given that the default iPhone message retention setting is keep messages forever, it would have to have been manually changed to 30 days. So a little hard to believe she didn't know. Certainly, Tom, we see parties state a lot that they didn't send or receive text messages like Susan Holmes said she didn't with Jennifer Holmes. But there are text logs available from the phone company that shows the parties you've communicated with and when. So why do you think more parties don't pursue those in discovery to highlight potential discovery failures?
Technical incompetence.
Well, there you go. That sounds like a potential possibility.
I think that may be a little harsh. It points out the complexity of what's going on here. You know, you and I were having a discussion with our friend Joy Hawley a couple of hours ago, and she said, you know, most people think that, you know, ESI is just email, and you just collect the box and give it to the other side, and that's the end of it. And obviously, we know it's not. And it's much more complex than that, and there's much more going on in the background. And so, you know, attorneys on either side of a case have to be up to speed with those sorts of technical complexities, you know, on the one hand to meet their obligations, on the other hand to point out if the other side hasn't met their obligations. So, you know, and it's not just messaging. I mean, Microsoft has tons of tracking logs for what goes on inside Microsoft server systems. And you just need to be up to speed on that in order to meet the ever increasing duty of technical competence, in my opinion. Yeah,
absolutely. I agree. And great point about the tracking logs in Microsoft. This isn't just limited to text messages. There's tracking in all sorts of communications.
And I just know the Microsoft. I'm sure that Google has similar things in their mail systems as well. You know, it really points out we'll talk about it in a little bit later in another case, but the communications between client and law firm.
Yeah, absolutely. So Judge Peck, do you agree that Susan Holmes' actions rise to the level of intent to deprive, or can they be more appropriately attributed to negligence?
Well, if it were just not knowing how the auto-delete function mysteriously changed to 30 days from the default, one could say maybe that was negligence, maybe it was ineptitude. We don't know, you know, if she got her phone new or, you know, got a hand-me-down from someone else. But saving some messages while deleting others after the litigation hold is in place certainly can be considered by the court to be proof of intent to deprive. And that's what the judge here decided. And so he let the punishment fit the crime, in the words of Gilbert and Sullivan, by not entering a default, but by adverse inference type instruction.
Right. Yeah, which certainly seemed like an appropriate sanction in this case. So certainly very interesting. And we'll move on to our next case, which was also suggested by Judge Peck. This was one of thousands of cases filed against the defendants regarding IVC filters, which included allegations that the filter fractured and fragments of the filter lodged in the plaintiff's heart, lung, and spine. During the plaintiff's deposition, she revealed she was writing an as yet unpublished autobiography stating, "I've written a book, it's in there." Plaintiff responded by producing excerpts of 3 pages of the book, which, as construed by plaintiff, mention or refer to the barred IVC filter at issue in the case. Defendants initially sought production of the whole book, but agreed to limit their request to portions of the book covering from the year 2000 through the present, consistent with medical records discovery in the case. Plaintiffs cited 3 objections in producing more than only the limited excerpts identified in a response to defendant's discovery. Any pages other than those produced are categorically irrelevant to the action, Even if it is relevant, producing the entire draft autobiography is disproportionate to the needs of this case and needlessly infringes on the privacy rights of plaintiff and third parties. And even if the autobiography is otherwise discoverable, a small portion of the document is protected by the attorney-client privilege and cannot be disclosed. In overruling the irrelevance objection, California Magistrate Judge Karen Crawford stated, "This case is, broadly speaking, about how plaintiff's life has been negatively impacted by the implantation of an allegedly defective inferior vena cava filter that fractured and caused her serious injury. Part of her means of showing the allegedly negative impacts on her life has been to testify that post-fracture, she can no longer do the things in life that brought her joy, at least in some respects. Thus, depictions of plaintiff's life, such as those likely to be contained in an autobiography, are relevant because they may rebut or bolster her claims about her limitations and the extent of her injuries." In addressing the proportionality objection, Judge Crawford stated, "Plaintiff claims extensive lifelong injuries in this case. As such, damages and the alleged limitations on plaintiff's lifestyle will be dominant issues at trial. Further, minimal expense or difficulty in producing the discovery is anticipated, as plaintiff already has the manuscript in her possession. An extra few hundred pages of discovery is not excessive when compared to the fact that plaintiff has already produced 3,000 pages of medical records, and in part because of the MDL litigation, defendant has produced copious discovery relevant to this and other cases." To address privacy concerns, Judge Crawford did rule that the names of third parties, and only their names, may be redacted to prevent the disclosure of their identities during discovery. And she ordered the parties to meet and confer over whether the court should conduct an in-camera review to rule on the claim of privilege. So, Tom, if the plaintiff hadn't already shown the autobiography to third parties, which she mentioned as a part of this discussion, would that have made a difference in the ruling?
It might have made a difference in degree, but remember, the judge started off by clearly stating that the autobiography itself is relevant, and then talked about ways to cut back on portions of it, and even acknowledged that they had agreed on a limited time frame. But overall, the judge was going to view, I think, some part of this was going to come in. Having shown it to a third party, I think, reduced the impact, if you will. I mean, it helped tilt the meter or weigh the scales in that direction. But again, by finding first and foremost that the autobiography itself is relevant, then it became a question of, because they, quote, agreed to limit their request to portions of the book covering from the year 2000 through the present, end quote, those sorts of limits were going to get material in anyways.
Sure. Yeah, it makes sense. So, Judge Peck, I was surprised that Judge Crawford ruled that the names of third parties could be redacted since there was a protective order in place. Do you agree that was necessary?
Well, I don't know that it was necessary. For the other people, it was probably something that made them feel better about it, but query whether this is going to just kick that issue down the road. I mean, some of them will not have any relevance. Others may well be ones where the defendant is going to come back to the court and say, for these people on these pages, we need to know who they are because we want to take their deposition based on communications they had with the plaintiff about her condition, etc. So it's protecting the non-parties, but probably for some of them only temporarily.
Sure. Yeah, that's what I was wondering. So, Mary, we see a lot of cases where additional evidence is identified during a deposition, like the autobiography was identified here. So what can parties do in preparing for depositions to maximize their potential to identify any additional evidence that might exist?
Well, certainly we heard about the online presence before of it, checking social media websites, also searching any prior sworn testimony or statements from the deponent, and then looking at the documents that have been produced. Looking at them certainly chronologically by person with the communication network, you might see something that's missing there. Paying special attention to the BCCs and on behalf of sends in the compound documents. Look at what the source might be of the compound document. For example, the small extract of this month's sales numbers in a PowerPoint might be generated from a full-on database. Same with spreadsheets. They oftentimes reach into bigger systems to update themselves. And then have standing questions where you might ask if the deponent has written anything about the matter or the issues at hand, even tangentially, or been recorded talking about the matter or issues at hand. So there's lots of ways to prepare.
Yeah, and certainly always good to, kind of have those various things. The more you understand the evidence, the more you understand what might be missing. So definitely great points there, Mary. So we'll move on to our next case. Actually, let's see. Question. Had she drafted the autobiography not as a single book or single unitized electronic file, but instead as a series of discrete separate chapters or so separate electronic files, would that have perhaps changed the analysis of whether the entire autobiography as opposed to portions of it was relevant? Thoughts?
I mean, I think if any of the material covered her life post the IVC filter having, burst, it probably is going to be relevant. And it's not so much that it was a single long autobiography, but that it was just like a series of emails. If it talked about her condition and her life, it should be produced.
Yeah, makes sense to me. I mean, had it been broken out where, like, here was my early life or something, and that was before, then obviously you could have discreetly excluded that piece. But it sounds like they're essentially doing the same thing within the autobiography. So, all right, great question. We'll move on to our next case. And the slogan of the defendant in our next case is "No rules, just right." But when it comes to preservation of video in a slip and fall case, you might want to have a few rules. Here, the plaintiff experienced a serious accident at an Outback Steakhouse in New Jersey, where she slipped and fell, not out back, but near the kitchen area, allegedly due to a greasy substance on the floor, a high traffic area frequently traversed by...
Did you just say not out back, but near the kitchen?
I did. I had to throw that in. Come on.
I had a delayed reaction there.
Yeah. Okay. Yes. I'm glad somebody's out there listening. So, so it was a high traffic area frequently traversed by servers carrying food and beverages. The fall resulted in significant injuries and emergency medical attention, as you see there on the slide. Following the incident, Outback's on-duty manager promptly reported the fall to the restaurant's insurance claims handler as required by Outback's policy. The restaurant's surveillance system captured the incident on video. However, significant portions of the footage were later overwritten due to the system's 7-day storage loop policy. Plaintiff's counsel sent a preservation letter to Outback 12 days post-incident, demanding the retention of all relevant surveillance footage from 24 hours before to 24 hours after Ms. Nagy's fall, which was after most of the footage was overwritten. Outback did preserve a 19-second clip specifically of the fall and a little over 27 minutes surrounding the event, but the plaintiffs contended that this was insufficient and argued that more extensive footage from before the fall was crucial to their case. New Jersey Magistrate Judge Douglas Arpert began by stating, given the circumstances and seriousness of Ms. Nagy's injuries, litigation was reasonably foreseeable. Indeed, it is apparent that defendants themselves immediately anticipated litigation. They contend, as discussed further below, that a record of information reported by Outback's manager on the day of the incident to claims administrator Gallagher Bassett is privileged because it was prepared in anticipation of litigation. Judge Arpert next addressed whether Outback had a duty to preserve video footage, stating, because litigation was foreseeable, Outback had a duty to preserve evidence that it knew or reasonably should have known would likely be requested in that litigation. Outback, a sophisticated business entity and experienced litigant working with an experienced claims administrator, should have known that more than 5 minutes of video footage prior to Ms. Nagy's fall would be relevant and would be requested by Ms. Nagy in any potential litigation. Under the circumstances here, the court finds that Outback had a duty to preserve the disputed video footage. He also criticized Outback for not taking reasonable steps to preserve the relevant footage, highlighting that Outback had no clear policy guiding its employees on how much footage to preserve in the event of incidents, leaving too much discretion to individual managers without proper guidelines. However, he opted for a permissive adverse inference instruction sanction instead of the mandatory inference sought by plaintiffs. So, Judge Peck, do you agree with Judge Arpert's decision for a permissive adverse inference instruction instead of a mandatory one?
I do. First of all, note that Rule 37E1 and E2 say that the court may order, etc. Doesn't say must. So the court has discretion. And here, maybe the floor by the kitchen was slippery. Maybe it wasn't. The video information would likely have helped, but it wouldn't have been necessarily dispositive. And so I think the permissive inference is okay, and the jury will consider that along with testimony from various servers, who walked by that area or whatever other information there is. I would note two other things. First of all, plaintiff was taken out by ambulance, and the Outback, somebody from Outback called the hospital and found out she was about to undergo surgery. I mean, that's a very different circumstance than somebody slips and is, walks out under their own steam and sues later on saying it was worse than I thought. And one last point, so it isn't lost. Remember that anticipation of litigation for work product protection is almost in all courts simultaneous with the need to preserve evidence via a litigation hold. So they didn't do that here, but claim privilege on that memo.
Right. Yeah, absolutely. Mary, I think Judge Peck's partially addressed this, but I'll ask it anyway. Given that plaintiff's counsel didn't send the preservation letter until 12 days after the incident, which was after Outback's 7-day storage loop policy, do you think the ruling could have gone differently had Outback done nothing to prepare for the possibility for litigation, or should they have still anticipated litigation regardless what actions they took?
Well, yeah, he did. He sort of told us about that, about the memo, and looking for privilege protection. And I'll just add that back in the day we'd pull a tape, the day's tape, but here, when they were documenting and saving the selective film, they were just writing it down to a thumb drive. So it's not that difficult to do. And I think this case is like the selective deletion of text messages, that if you select the video, you better well do it so that it passes the sniff test.
Sure. And great point, Mary. And one of the things about it being selective, Tom, was that there was a lack of standard procedures for Outback managers on steps to take and how much video to preserve. So what advice do you have for our audience on standardizing their approach to incidents like this, including when they should get counsel involved?
Well, two things. As far as standardizing their approach, you got to have one. In this case, the judge, as you put there on the screen, it left too much discretion to individual managers without proper guidelines. It reminds me of the case we had several months ago about the county jail, where a corrections officer was given complete discretion as to what tapes would be saved or deleted. You can't do that. You got to have a policy. You got to have a standard policy. It should be written. It should be, disseminated to everybody. It should cover all sorts of contingencies. And if you're not sure, then, what should be included there. If there's any questions, and obviously there may be many, In this case, the judge, I think, was probably a little miffed that the judge said at some point, we're talking with about a large company here that's sophisticated and should have known better. But either way, I think you want to get counsel involved, pretty much like the old saw about voting in Chicago, right? Early and often.
Right.
Get some advice so that you can say you made a reasonable attempt to do this. It wasn't just, I think, discretionary. With one individual is the key here, and show the court that there was some attempt at a standardized procedure, and that we at least tried to follow that.
Yeah, great points. And you pointed out that other case where the court specifically pointed out that the police lieutenant unilaterally decided what video to preserve there, and you never want a custodian being unilaterally making those determinations. Just like Mary pointed out in the text messages case, she was unilaterally deciding which text messages to keep and not. So it's certainly good to have some stated policies at least you can hang your hat on. And
Doug, we're seeing a lot of cases of premises liability, whether it's a restaurant chain or a department store. There was a recent case, I think, involving Target. And I wonder if they're just not getting good legal advice, or if somebody has made the decision that having to really do a good job of preserving these videos is going to cost more than then they're going to get hit with verdicts, and on a cost-benefit analysis, they're just going to take a somewhat half-assed approach to this.
Yeah, well, that's a fair point.
Yeah.
Go ahead, Tom.
No, I totally agree. I mean, the cases where I've been involved, it's clear that there's a cost-benefit analysis being done. What can we do to implement this? Again, the size of this company, I think, was a factor.
Sure. And question from the audience: had the Outback manager been instructed by legal counsel rather than just exercising his own discretion to only preserve around 30 minutes surrounding the incident, would that have changed the outcome?
Wow.
Go ahead, Tom.
No,
well, if he was instructed to save the right amount of video and then just didn't, that might be different than there not being a policy. But ultimately, in these sort of cases, and I had some in front of me, you have to prove that the slippery substance or whatever caused the fall existed on the floor long enough that the restaurant knew or should have known, and to clean it up. So how much time, may depend on if they did a sweep, pun intended, of the restaurant every half hour to see if there was anything slippery on the floor. Then maybe a half an hour of video would have been a good policy. If they made a sweep every 2-3 hours or twice a day, then you might have needed a lot more time.
Right.
Sure.
Right.
Yeah, that makes sense. Consistency with policies, regardless whether it's unilaterally done or with advice of counsel, always a good policy. So, great question and interesting case. And we'll move to our last case, which involves an MDL regarding allegations that Uber failed to implement appropriate safety precautions to protect passengers, which led to alleged incidents of sexual assault or harassment by drivers using the Uber app, and was, you guessed it, suggested by Judge Peck. The parties began to meet and confer to discuss the scope of Uber's evidence preservation efforts, as well as proposed protective order. Uber declined to provide certain information regarding its preservation efforts until a protective order was entered, so plaintiffs filed a motion 4 days before the final protective order was issued, after which Uber provided some information concerning its preservation efforts. In the motion, plaintiffs requested that the court order Uber to immediately produce litigation hold details, including the names, job titles, and dates of employment of the recipients of the hold notices, among other things, immediately disclose information regarding ESI sources that it has preserved and when it preserved them, and suspend Uber's company-wide document destruction policies to allow plaintiffs to determine what, if any, relevant ESI has been destroyed. After receiving info from Uber, plaintiffs submitted a supplemental declaration indicating that Uber had produced a list of the job titles of approximately 15,700 past and current Uber employees subject to a legal hold, but no names. Uber also confirmed that it had produced documents from proceeding with the California Judicial Council on coordination proceedings, which it claimed represented all the information plaintiffs sought as to Uber's ESI sources, including custodial and non-custodial sources. California Magistrate Judge Lisa Cisneros stated, Uber argues that the Rule 26F checklist plainly states that parties may provide the names and/or general job titles or descriptions of custodians for whom ESI will be preserved. Uber's position is not supported by the applicable law. In ordering Uber to produce litigation hold information, Judge Cisneros stated, plaintiffs are entitled to information to evaluate whether Uber has met its preservation obligations. Given that a sexual assault or sexual harassment case or complaint has the potential to put Uber on notice of its duty to preserve potentially relevant evidence, it is warranted that Uber specify whether the litigation hold pertains to a sexual assault or sexual harassment case or complaint involving a driver using its application. As for the request for ESI sources, Judge Cisneros granted and has stated in granting that request in part, courts routinely hold that parties are entitled to know what kinds and categories of ESI a party has collected and preserved and what specific actions were undertaken to that end. Thus, the disclosure of information indicating non-custodial sources of the ESI is expected in the ordinary course of discovery. As for the request that Uber suspend its company-wide document destruction policies, Judge Cisneros stated, Uber, for its part, argues that such a request is overbroad. Uber points out that it conducts business that's unrelated to its rideshare application. Yet plaintiffs seek a company-wide suspension of Uber's policies that provide for the automatic deletion of data. Furthermore, Uber contends there's no legal basis to support plaintiffs' request to completely suspend Uber's document destruction policies. The court agrees. Plaintiff's request is exceedingly broad, so she denied that request without prejudice. So, Mary, 15,700 past and current Uber employees is a lot of custodians subject to a legal hold. Do you think Judge Cisneros would have ruled that the names of so many custodians might have been required if the nature of the case was less sensitive?
No, I think it's the other way around. It's like, I think there's a reason not to tell us the names. I mean, that you'd have to go and ask permission about. Certainly the details of who you sent the legal hold to and when you sent it and what ESI is involved. That's all fair game. Not so much, the discussion of the issues of the case or what, that kind of thing. That's more work product related. But I've never seen it where, unless it's been whistleblowers or something like that, where the custodians' names were withheld like that.
Mm-hmm. Okay.
All
right.
I'm curious if any of my colleagues here know, were most of the 15,700 Uber drivers, and did they have an Uber email account, or were they just told to, save all their Gmail or personal email? It strikes me as a very large number, and I would be dubious if, drivers who Uber has always argued were independent contractors and not employees got an Uber email account.
Yeah, that certainly it certainly seems like they would probably have their own email account, and obviously that complicates discovery if they do, because you're issuing well, it says Uber employees though, so I guess what does that mean by employees? Because they are subject to a legal hold. So good question. I wonder about that because, yeah, like you, I've always understood them to be independent contractors. But yeah, Certainly, they said 10,200 were subject to legal holds not in connection with this litigation. So very interesting consideration there. Judge Cisneros ruled against the plaintiff's request that Uber suspend its company-wide document destruction policies without prejudice. Do you think she would have granted it had the request been more targeted to exclude ESI sources not related to the rideshare business?
Well, I'm not sure if that would be the specific category or criterion, but certainly the judge was saying you needed to be more targeted. Yes. I mean, you have it right there on your last paragraph on the screen. Plaintiff's request is exceedingly broad. By saying they wanted the whole company, I mean, they have to know that I thought they were walking the tightrope of boilerplate language here, putting out a request like that. So, yeah, certainly if they had come in with something more reasonable, the judge might have been more likely to grant it.
Right.
It also,
and she didn't. Oh, go ahead.
Also shows, as a matter of strategy, if you go for the grand slam home run, you're likely to get nothing. If you go for something targeted, then you might get, your single might drive in a run down the road, to keep the baseball metaphor going.
Oh, the Tony Gwynn strategy. There you go.
There you go.
Yeah.
That's right. A little, yes, Whitey Herzog. There you go. He just passed away. Yes, great baseball analogy to the idea. And she did deny that request without prejudice. So it certainly does give her give the plaintiffs the ability to reposition more targeted. So Judge Peck, does the information the plaintiff sought amount to discovery on discovery, or should they have been entitled to the information anyway?
Well, it's a slippery slope as to what is or isn't discovery on discovery. And I think this is not. I mean, who is on hold, when the hold was put in place, is pretty basic information. And you need that to be able to see whether an additional hold needs to be issued. Similarly, the non-custodial sources. You have to know what they are in order to know whether they should be on hold. So I would say this is on the side of the line that is subject to discovery and not barred by discovery on discovery. And I'll note that Judge Cisneros cited the eBay decision back from the dark ages, 2007. And that case had held that you're entitled to ask who is on hold and when the hold was issued, but not what they were told. What they did is okay. What they were told is likely to be attorney-client privilege or work product.
Okay, yeah, fair point and distinction there. So great point there. All right, so now for our contacts page, and our next case law webinar, as Kaylee mentioned at the top of the hour, is on Thursday, May 30th. The beach ball represents that some of you may be starting your summer vacations by then, but you still want to register for the webinar to make sure you can get the slides and check out the webinar on demand. So with that, I'll say thanks to Mary, Tom, and Judge Peck for their terrific insights as always, and I'll turn it back over to you, Mary.
Thanks, Doug. And we thank you for anchoring, and Tom O'Connor and the Honorable Judge Peck for this wonderful presentation. Our thanks to the EDRM community for your kind attention. If you really loved it, show the Honorable Judge Andrew Peck, Tom O, and Doug Austin from Houston some love. Find your emojis at the bottom of your console. And as Doug mentioned, we do have on-demand webinars. So to be automatically registered for that, click the pop-up at the end of this session. Once there, scroll down and you can click the bell to subscribe for updates. And we'll see you next time on the EDRM Global Webinar channel. Thank you.
Thanks,
Hey, everybody.
Bye, all.